Hi, I am Emelyne Calimoutou. I am an associate counsel at the World Bank. I am glad to be here to present the result of my legal research on child marriage, published under the Compendium on International and National Legal Frameworks on Child Marriage. I've started to work on this issue 4 years ago and discovered it through the picture of the photojournalist Stephanie Sinclair. Stephanie Sinclair published powerful pictures of child marriage around the world and advocate to end this harmful practice. I invite you to visit her website Too Young to Be With to see her work. The picture that you are seeing right now is a picture of two classmates, child brides, who were married at 6 with their husband. They are all from Yemen. I also discovered child marriage through a poem, the poem of Helen, 13 years old, from Malawi, which I would like to bring to your attention. This poem is entitled I Will Marry When I Want. I will marry when I want. My mother cannot force me to marry. My father cannot force me to marry. My uncle, my aunt, my brother or sister cannot force me to marry. No one in the world can force me to marry. I will marry when I want. Even if you beat me, even if you chase me away, even if you do anything bad to me, I will marry when I want. I will marry when I want, but not before I am well educated and not before I am all grown up. I will marry when I want. These poems highlight the fact that children married at a very young age are not given the choice to marry when they are ready. They have been forced to give up school and start a family and end up facing severe health issues such as early and unwanted pregnancy, sexually transmitted infections, obstetric fistula, and female genital mutilation. Now that I've introduced the topic, I would like to define child marriage under international law. Child marriage is a marriage in which one or both spouses are under 18 years old. There are therefore three main components in this definition. First, what's a child under international law? A child is every human being below the age of 18. This definition is established by the Convention of the Rights of the Child, one of the most universally endorsed and widely ratified treaties in history. This is also the legal definition used in most parts of the world. Therefore, child marriage is a marriage in which one or both spouses are under 18 years old. How marriage is defined. The concept of marriage also varies. It can be formal or informal. It can be governed by civil laws, common laws, or religious law, or simply be a customary practice. In many parts of the world, for example, marriages can be recognized by the community without legal registration. Then 18. 18 marks the age of majority in a number of countries. In a small number of countries, adulthood or the age of majority may be reached before age 18. The Convention on the Rights of the Child makes an exception for national laws recognizing an earlier age of majority. Is child marriage common? Every year, 12 million girls are married before the age of 18. That's 23 girls every minute, nearly one every 2 seconds, according to UNICEF. Where does child marriage occur? Child marriage occurs in every region of the world and is practiced across cultures, religions, and ethnicities. To give you an idea, 45% of 20 to 24 years old girls married before 18 were living in South Asia in 2016, 39% in Sub-Saharan Asia, 23% in Latin America and Caribbean, 18% in the Middle East and North Africa. The highest rate of child marriage by country are observed in Sub-Saharan Africa, in countries such as Niger, Central African Republic, and Chad. However, the largest number of child brides live in South Asia, where 46% of girls are married before the age of 18. What is the current trend? The prevalence of child marriage is decreasing globally, with several countries seeing significant reductions in recent years. 25 million child marriages prevented in last decade due to accelerated progress, according to a new UNICEF estimates in 2018. Overall, the proportion of women who were married as children decreased by 15% in the last decade, from 1 to 4 to approximately 1 in 5. South Asia has witnessed the largest decline in child marriages worldwide in the last 10 years.
What are the drivers of child marriage? Child marriage is mainly driven by gender inequality, tradition, poverty, and insecurity. In many communities where child marriage is practiced, girls are not valued as much as boys. They are seen as a burden on their family. Marrying your daughter at a young age can be viewed as a way to ease economic hardship by transferring this burden to her husband's family. Child marriage is also a traditional practice that in many places happens simply because it has happened for generations. Harmful traditional practices can be linked to each other. In some places, such as southern Ethiopia, child marriage usually follows the practice of female genital mutilation. More than half of girls from the poorest family in the developing world are married as children. Families who are facing poverty sometimes think that girls themselves believe that marriage can be a solution to secure their future. Many parents marry their daughter young because they feel that it's in her best interest, often to ensure her safety in areas where girls are at risk of harassment and physical or sexual assault. Child marriage can increase in humanitarian crises, such as in conflict or after a natural disaster. 9 out of 10 countries with the highest child marriage rates are considered fragile states. What are the consequences of child marriage? Child brides are neither physically nor emotionally ready to become wives or mothers. They face more risk of experiencing dangerous complications in pregnancy and childbirth, contracting HIV/AIDS, and suffering domestic violence. With little access to education and economic opportunities, they and their families are more likely to live in poverty. What does the law say? The Compendium of International and National Legal Frameworks on Child Marriage provides a survey of the key international, regional, and national legal instruments as they relate to the right to marry, with the full and free consent of the intending spouse, and to the obligation for government to take legislative measures to abolish child marriage. The Compendium lists all the international and regional agreements prohibiting child marriage, such as the Universal Declaration of Human Rights, the Convention of the Elimination of Discrimination Against Women, the Convention on Consent to Marry, Minimum Age for Marriage and Registration of Marriage, the Convention on the Rights of the Child, the Maputo Protocol, the African Charter on the Rights and the Welfare of the Child, the Inter-American Convention on Human Rights. These agreements set standards that governments should adhere to protect children from being married before they are ready. These standards act also as an accountability measure because governments have to report to the committees that oversee them about how they are implementing these standards. These standards can be used to hold governments accountable for failure to implement and enforce their obligations related to child marriage under these conventions. The Compendium on International and National Legal Framework on Child Marriage lists also the legislation of 69 countries. Their analysis revealed that most countries around the world have laws that set a minimum age of marriage, usually at 18. However, many countries provide exceptions to the minimum age to marry, upon a parental consent or authorization of the court. Other exceptions allow customary or religious law that set lower minimum age of marriage to take precedence over national law, such as in Eritrea and Niger. Such exceptions undermine the efficacy of the legal protections against child marriage. What are the main exceptions to the minimum age to marry under national laws? The compendium provides an analysis of domestic laws around the world that set a minimum age to marry and show that most of them contains exception to the minimum age to marry in case of grave cause, serious grants and grounds, authorization or consent from their parents or legal representative, pregnancy, or to avoid criminal sentence in case of statutory rape. To see the importance of having a coherent legislation on the minimum age to marry, let's study the case of Malawi. The legal minimum age of marriage in Malawi is now 18 for men and women. An harmonization of both the legislation and the constitution was an important step reached by Malawi. Indeed, before the parliament voted to amend the constitution to make marriage before the age of 18 illegal and removing a provision that allowed children to marry at 15 with parental consent, the 2005 Marriage, Divorce and Family Relations Bill, stating that the minimum age to marry for women and men is 18 years old, was inconsistent with the constitution. Therefore, there was no absolute ban of child marriage in Malawi because of the Section 22(7) of the 1994 Constitution, which still permits children between the age of 15 and 18 to contract marriages with the consent of their parents and guardians. In February 2017, the Malawi parliamentarians agreed to amend the Malawi constitution and raise the age of marriage from 15 with parental consent to 18 years old for both boys and girls, following more than a year-long campaigns by youth groups and organizations. The President signed the constitutional amendment into law at the end of April 2017. This was an important step as the Marriage, Divorce and Family Relations Bill adopted in February 2015, which set the minimum age of marriage at 18, is now in line with the Constitution. In addition, Malawi chiefs are also helping to fight against child marriage. Indeed, over the 3 years, the senior chief Teresa Calimoutou annulled 850 underage marriages in the poor rural area in the central region of Malawi. More recently, she also decided to make 50 of her sub-chiefs sign an agreement to end child marriage in her area of authority. Why advocating for a coherent legal framework to end child marriage? A multi-sectoral approach is needed to reduce the practice and improve the effectiveness of legal provisions. This should include a coherent legislation, specific policies and programs, as well as communication for behavior change framed within a comprehensive national strategic plan. A coherent legislation means laws that do not contradict each other, laws that contain no exceptions to the minimum age to marry, more comprehensive laws that include access to justice for victims of child marriage and include components on registration of marriage and birth, financial resources allocated to the implementation of the laws, specifically in rural areas.